I'm Bert Tenzer.
I'm Bella Shaw.
I'm Doug Llewellyn.
And I'm William Shatner, and this is Heartbeat of America. Since 2001, our television series has been featuring entrepreneurial companies that move our country and our economy forward. Standing by at our studios in Los Angeles is one such company. Welcome. Good to have you with us. All right, let's begin by telling me what you do and who benefits from it.
Well, I'm a criminal defense attorney, and we specialize in alcohol and drug cases. Most of these are driving cases, driving under the influence of either alcohol or drugs. And we handle approximately 1,000 cases a year in our firm based out of Atlanta.
Well, you're obviously successful. So what do you attribute your success to? Any particular philosophies or strategies?
Well, while most attorneys are pleading people guilty or telling them why they don't have a case, our job is to find out what's wrong with the case. Once we find out what's wrong with the case, our job is to win the case. We've been successful in about 75% of all cases we handle, and in my own particular case, about 93% of those that I take, we win or get a non-DUI disposition.
Now, stay with us. There's more to come.
We are back again now with William Head. He is the senior partner of Head, Thomas, Webb & Willis, LLC. It's a law firm in Atlanta that specializes in DUI cases. These are criminal defense cases, DUI and drug cases. We're going to hear some of the examples of the kind of cases you've handled, and you've done so many over the years. Some of them are absolutely amazing. Some funny, some tragic. Give me an example of some of the ones that come more prominently to your mind.
Well, one of the most recent ones even amazed my paralegal, Allison, who's been with me for 14 years. I took it over from another attorney. It was a lawyer charged with .26 blood tests. Facts were that as he sat in his driveway with his wife in the car, 3 seconds later, the car shot through the garage door, out the back wall of the house, across the railing of the deck, launched 28 feet into the backyard and hit a tree. And he was charged with DUI because, again, there was no driving scene except what happened in his own driveway and through his house.
Even in his own yard, he could be charged with DUI?
Yes, most states are that way, and Georgia's that way. But anyway, the first lawyer didn't know what to do with the case and was ready to plead him guilty. He said, I can't have a guilty on my record. So he came to me. We tried the case as a bench trial, and he was found not guilty of everything. And that includes the DUI on both per se being above the legal limit, as well as the less safe case, which just means the common law case of being too drunk to drive.
I mean, he wasn't just above the limit. He was way above the limit.
More than 3 times the limit, according to the blood test, which we got thrown out.
Don't judges look more seriously at a case like that? Well, would they like to convict, the judges?
Many times the judges would like to convict, and I recently did one on a .166 blood test rollover wreck where the blood was thrown out, and the judge knew it. It was another bench trial, and he had to acquit that young man, and he gave him a good piece of his mind and said, you're very fortunate you didn't get convicted because you had many a day in jail if you'd lost this case.
I mean, I can see where it would infuriate a judge if he wants to send this guy away and you come along and you get him off.
Well, most judges, including the one on the .266 case, was very, very complimentary that the case had been won because the prosecutors just weren't ready for what we had. But we proved that that case that went through the garage, that the car had a known sudden acceleration problem. In fact, it was a BMW 1995 525 series. Our expert found that all 418,000 had been recalled for sudden acceleration, but this one had not been fixed. And so many years afterward, the problem appeared, and it appeared at a very bad time because his house took the beating.
So whether that was really the cause or not, it was sufficient in court to have him prevail.
It was sufficient in court, and the blood test was thrown out based on officer error in the middle of trial, so the judge only had the less safe common law type of DUI left.
Yeah.
And when it came to that, he had more than enough doubt once the expert testified that all of these cars had the problem. The federal government, NHTSA, took them all back, and this case ended up getting knocked out on a not guilty.
That's pretty fascinating. There are tons of others I'd like to... Give me another one.
Another one that I use in some of my talks to public safety officials, I teach at Georgia Tech sometimes, is a speeding case, 86 and a 65, 19-year-old college student going back to school. He had a .059, which is not a high reading, but it's still above the legal limit of .02 in our state, which is for underage. He also admitted to the officer on video that he smoked marijuana before he drove, and he had marijuana in his pocket. And in that particular case, my job was to take it piece by piece, and we did another bench trial, a non-jury trial, because I didn't think any jurors were going to be too amused by this young man's activities. And by the time I finished cross-examination, the only type of DUI that the officer thought he really had was being above the legal limit, because when he did the field test, he didn't find any signs of impairment, none of the usual signs that you see. And so he admitted that all those other cases really weren't supported by the evidence. But on the per se case, what he had done wrong is when it got to the portion of reading the person his rights, he didn't do it outside the car, which usually happens. He put him in the back seat, and then he turned his own audio off. He left the video running, but turned the audio off. My client took the stand and testified that he never read me my rights. The officer said he did, and the judge was put in the position of having to decide what to do. I convinced the judge that why would an officer with all this expensive equipment turn it off at the most critical time? And the judge, very upset about it, even said in open court, I don't want this pot-smoking, drinking, speeding teenager on the road with my wife and kids, but officer, you screwed up. It was your job to capture this evidence. You've got the burden of proof, and it makes me sick, but I have to find him not guilty. And he did. He found him not guilty, because that's what the law required that he do. He had a doubt about the case because my client took the stand. He said, yep, I smoked pot. Yep, I had marijuana in my pocket. Yep, I was drinking, and that alcohol level's probably right. And every question they asked him, he answered very truthfully, because it wasn't about impairment. It really wasn't about impairment. And I know how to break the cases down into what's important for each case.
And briefly, what about cases that involve, for example, a mother driving with children in the car? Are they harder on them?
It's a very, very tough case. In fact, recently, Justice Scalia from the U.S. Supreme Court's daughter had one of her children in the car in Illinois, and one of my friends, Don Ramsell, handled that case. And she was facing 6 months mandatory jail just for having the child in the car.
Exactly, yeah.
And he was able to work that down to a plea that kept her out of jail. He did a remarkable job. But yes, when children are in the car, judges nor juries have a sense of humor about hearing the case, and it's very hard for anybody to be fair in those cases. They can be won, but they're among the most difficult cases.
It's such a fascinating subject, and you know, I'm sure there's some people that look askance at an attorney like you. You know, it's just like attorneys who defend criminals, murderers, who you know they did it. But that's your job.
That's
and
exactly
you're out
right.
there to prevail.
Well, my job is, again, to look for the problems, and if there's no problem, the officers who know me and know me well, they have no grudge with me at all. They say that every time they come to court, it's like going to a seminar, and they're better officers when they leave. The ones who like to hide things and the ones who are perjurers, my job is to get those people out of the system, and I have had many of them fired, many of them prosecuted, because many of the judges will say just what I say. There's nothing worse than a cop who takes an oath and then turns around and lies under oath in court.
We'll be back in just a moment.
We have been watching the operations of an organization which is doing its part to keep America strong, and we've been learning from its leaders about what they're doing to help move our country forward. This organization represents companies across our great nation that embody the spirit, dedication, know-how, and can-do attitude which has made America the great nation it is today. And now let's present the Keeping America Strong Award.
Now it is my honor to present this prestigious award to William C. Head, the senior partner of Head, Thomas, Webb & Willis of Atlanta, for the outstanding work that this gentleman and his firm are doing to help keep America strong. William, it's a pleasure to give this to you. Congratulations.
Thank you very much, and want to accept this on behalf of all the attorneys. I don't do that many cases anymore. I just oversee things for the most part, and those attorneys are all doing a great job, and they need to share this plaque with me.
Congratulations for earning the Keeping America Strong Award, which honors innovators and leaders like you who are the heartbeat of America.
For more information on this law firm's services, you can visit their website. It's very simple, GeorgiaCriminalDefense.com.
I'm William Shatner. Thanks for watching.